My name is David Lubofsky. Thank you, Madam Speaker, tonight, and Senators for allowing me to give testimony again in support of Bill 11236 as substituted. I won't spend time on my story, as you all by now are familiar with my son, Asher, but are you familiar with the hundreds of other medical negligence stories? Of course, you are not, as there is no path for them to bring their tragedies to light in the current draconian system. This will change with Bill 11236, using the mandatory pre-screening process with a judge in lieu of the expensive arbitration MMAA. I do suggest that the statute of limitations, which is only 1 year now, be extended to 2 years. This is similar to other locations, 2 years, and some places have 3 years to file. Also, as the speaker alluded to, the clock should stop once the 45-day notification to a healthcare provider is made by a complainant of intent to file to prevent the statute of limitations from running out while they negotiate. I also further suggest that you may want to add language here as to what happens after the 45 days if the complainant does not file. Notifying a medical provider of intent to file and have that provider pay legal fees, etc., and then nothing happens would be an unfair hardship to a medical provider. So in other words, what I'm saying, you give them the 45 days, the doctor runs out and finds a lawyer and does consultation, then nothing happens after the 45 days. That's money that the medical provider has spent, and nothing, it doesn't go any further than that point. This could be a point of termination in the process if the 45 days lapses without cause and nothing is filed without a valid reason. It would also help to prevent frivolous claims. One issue, my trigger issue that I have with the pre-screening, it states that the judge will use any findings of fact and decisions made by the Guam Health Licensing Board on the same subject of complaint. Realistically, I know that there's nothing I can say that will change this, but for the record, and to show some of the issues, I'll tell you why I feel that way. The Guam Board of Medical Examiners, and many doctors in Guam have said, let's have the Guam Board of Medical Examiners look at these cases. Let them be in charge. They can determine what's going on. The issue with that, and that's not a bad idea, but the issue with that is the Guam Board of Medical Examiners, in 4 years, and approximately 47 cases, if not more, has never, ever decided in favor of a medical consumer complainant. The board chair has petitioned some of the senators stating the current law, MMAA, should not be changed. The board doesn't notify, the current board as now, doesn't notify complainants of the statuses of their cases against doctors, and it's closed cases without ever informing the complainant. The medical board is in court. They've been sued and it's, for failing to set up basic consumer investigative procedures as ordered by Judge Barcinas in a writ. They refuse to put medical negligence settlements into doctors' profiles as required by Guam law, or to inform the public unless the doctor has 3 settlements in 4 years. So in their world, the Guam Board of Medical Examiners world, 3 must die negligently to warrant notifying the public about the doctor's history or medical negligence. I don't think there's anybody that would agree that that's a good thing to do, but that's the way it's set up now. Bill 112 will improve medical care by not allowing negligent doctors to keep practicing as they are now. Let's keep one thing in mind. 1% of doctors commit 32% of malpractice nationally. On Guam, those doctors are not identified as in other places, which degrades medical care on island and puts us at greater risk. Doctors who are considered washed up or have histories of medical negligence reportedly gravitate to Guam. Being that it's easy to get licensed here, there's no need for medical accountability or no need for malpractice insurance. Even the Guam Assistant Attorney General, Rob Weinberg, stated in a board meeting that Guam has the reputation of attracting washed-up doctors. And this is all due to the current law, MMAA. I strongly support the amendment regarding the standard of care by a reasonable physician that provides care in another specialty because of the unavailability of a practitioner on island in a medical crisis. Of course we need to do that. This is a great idea, of course, and practical, and will save lives. Just like equally identifying negligent doctors will save lives. It's my opinion you will not find one good Guam doctor who came to the island to escape malpractice insurance or to not be held accountable for medical negligence. I've been here almost 50 years. I've never heard of such a thing. That is not why doctors come here, but it's used as a primary reason to not change the current law. If you find such a doctor, as Assistant AG Weinberg implied, they probably came here due to Guam's reputation of being a place for washed-up doctors with no accountability, thanks to the MMAA current law. Also, you will not find Guam doctors who will leave the island if the law is changed. This shallow threat does not hold water when you ask them individually, or as they were asked in a past hearing. I believe there was seven doctors at that hearing. Dr. Shea has said, Guam doesn't need doctors in a Guam Post interview he did a few years back. He said we need specialists. Specialists is exactly what we need, but specialists will find it difficult to come to Guam if they have to compete with other doctors already practicing on Guam, as is now because of the MMAA, who practice outside of their special area. Guam doctors work outside of their expertise. And they compete, that's competing with any specialist who wants to set up shop on the island. It's a catch-22. We can't get doctors. Well, the doctors have to work outside their area. So therefore, we can't get doctors. Well, I can't set up a shop there because I have to compete with doctors with a small population. This is the other dark side of the negative impact of the MMAA on healthcare. It's also, by the way, the definition of malpractice as was stated in a past hearing. Don't get me wrong, Guam has great doctors. I have like 6 doctors that I see, no names mentioned. Bill 11236 is not about them. It's about the others who hurt or kill or sexually abuses the people of Guam while being sheltered by this law and freely walks to the next potential unknowing patient victim. I just hope this legislative body can listen to the people of Guam who do not have financial interests at stake like the doctors who oppose changing this law. A white coat, with all due respect, doesn't know more than the rest of us outside of the medical area regarding public policy. We elected the senators, not them. I also wonder why, when there are meetings to discuss reforms, medical negligence reforms, that they are closed door. No consumers or stakeholders allowed. It's actually an insult. Are our opinions and information not valid or informed enough, or do we raise issues that cannot be responded to? Please listen to both sides. People are dying, and it relates back to this law. The MMAA, the current law, has been the worst thing, in my opinion, to happen to health care on Guam in 3 decades. And at the very least, has run its course of usefulness. Thank you.
Thank you, Mr. Lebowski. All right, we'll proceed with Attorney Mitchell Thompson.
Madam Speaker, committee members, good afternoon. My name is Mitch Thompson. I've been an attorney in private practice here on Guam for over